Can a credit card company or debt collector sue you? Falling behind on credit card payments can feel overwhelming, especially when you start to worry about the possibility of being sued. While lawsuits from credit card companies don't happen after just one missed payment, continued non-payment increases the chance of legal action. If you've received a lawsuit or fear one may be coming, we're here to help you understand what you need to know and what steps you can take to protect yourself. If you're struggling with debt, try our free debt relief calculator, as it's designed to help you figure out which options might work best for your situation, including the pros and cons of each approach. We know it's tough to find the right option, especially when so many companies out there are trying to push you into something that might not even fit your need. Our goal is to give you unbiased information to help you make the best choice for your financial future. First, it's important to understand that lawsuits are typically a last resort for a credit card company. Filing a lawsuit is costly, time-consuming, and labor-intensive. Companies usually try other collection methods first, like sending letters, making phone calls, or even visiting you in person. But if those efforts are ignored, a credit card company may escalate to legal action. If you're served with a lawsuit, don't ignore it. That's the first and most critical step. When you receive the lawsuit papers, carefully review the summons and complaint. The summons will outline the timeline you have to respond, which is often between 14 to 30 days, depending on your state. Missing this deadline could result in a default judgment, which allows the credit card company to automatically win the case and garnish your wages or your bank account. If you're unsure about your next steps or need guidance, call us at 833-272-3631. Our team is here to help you navigate this situation with the support and advice you need. Mark the deadline on your calendar immediately. Set reminders for a few days in advance so you have time to gather everything you need to file your response. Filing a written answer to the lawsuit is the first step to defending yourself and stopping the default judgment process. Why is filing an answer so important? Because most people do not do it. Over 95% of debt lawsuits go unanswered, which is exactly what creditors hope for. By not responding, you're essentially handing them a victory, allowing them to garnish your wages, freeze your bank account, or take other legal actions to recover the debt. Filing an answer gives you a fighting chance to contest the lawsuit and explore your options. If you're wondering whether bankruptcy or debt settlement might be a better fit for your situation, use our free debt relief calculator to explore your options and weigh those pros and cons. We understand how stressful this can be, and our calculator can give you the clarity you need to make an informed decision without feeling overwhelmed by all the competing options out there. Speaking of the statute of limitations, it is worth checking whether the debt is even collectible. Credit card debt has a time limit for lawsuits, which varies by state. If the debt is too old, the credit card company may no longer have the legal right to sue you. Be cautious not to make any payments on old debt, as this can reset the statute of limitations and reopen the window for a lawsuit. Another option to consider is settling the debt. You can reach out to the creditor or their attorney to negotiate a payment plan or lump sum agreement. You can reach out to the creditor or their attorney to negotiate a payment plan or lump sum settlement. Many creditors are willing to settle for less than the full amount owed, especially if it saves them the time and cost of litigation. Remember, settlement discussions are protected under most state rules of evidence, so they can't be used against you in court if the case proceeds. Not sure how to approach a settlement or whether it's the right move? Call us at 833-272-3631 for personalized guidance. In some cases, filing for bankruptcy may be the right solution. Bankruptcy can halt lawsuits, wage garnishments, and other collection actions, giving you time to reorganize or eliminate your debts. However, this is a significant decision and should be weighed carefully against your other options. Finally, avoid admitting fault during any communication with the creditors. Assume that every call or letter is being recorded and can be used as evidence against you. Instead, focus on asking questions, requesting documentation, and exploring your defenses. The key takeaway is this: act quickly and do not ignore a lawsuit. By filing an answer, exploring settlement options, or considering legal defenses like the statute of limitations, you can take control of the situation and avoid the worst consequences. If you're not sure where to begin, our free debt relief calculator is a great place to start. It helps you see which options are available and which ones might be best for your situation. If you do have questions, call us at 833-272-3631. The sooner you take action, the better your chances of resolving the lawsuit on terms that work for you. Take charge, stay informed, and give yourself the best possible chance to manage your financial situation.